U.S. District Judge Dana Christensen said the 22 plaintiffs in the case Lighthiser versus Trump had legitimate concerns about the environmental impacts of the federal government's policies, but he didn't believe he had the jurisdiction to give them the relief they were looking for. Last month, Christensen held a 2-day hearing on the case in Missoula. The plaintiffs range in age from 7 to 25 and live in 5 states, including Montana. They wanted to block 3 of President Donald Trump's executive orders aimed at unleashing energy development. They argued increased fossil fuel development would directly harm them. Federal attorneys argued it would be overreach for a judge to stop the government from reconsidering a previous administration's policies. In the end, Christensen ruled the plaintiffs had demonstrated climate change and fossil fuel impacts were a health emergency. But he said if he blocked the orders, the court would have to review hundreds of administration actions to see if they complied with the injunction, and that would be, quote, an unworkable request. The law firm representing the plaintiffs said they'll appeal the decision to a higher court. They said, quote, courts cannot offer more protection to fossil fuel companies seeking to preserve their profits than to young Americans seeking to preserve their rights. 15 of the 22 plaintiffs are from Montana, and 10 of them were also plaintiffs in the held climate lawsuit, in which they successfully challenged Montana's greenhouse gas policies in the state court system. In that case, they were able to point to the Montana Constitution's guarantee of a clean and healthful environment, and that's a specific protection that's not in the U.S. Constitution. In Helena, Jonathan Amberian, MTN News.